So, as an investor, what should I be looking for if a startup claims that they've got a patent on their product?
If you are an investor and you're reviewing an investment into a company and they claim that they have filed patent applications, here are the things you should check for. First, you need to understand if they have provisional patent applications or non-provisionals. Provisionals are temporary patent applications that need to be converted into a non-provisional within 1 year. And startups can do this to save money, and that's a very worthy goal. However, the application should have a lot of details in it in order for the provisional application to have any value. So let me give you an example of a good, high quality provisional. Those are done typically by drug companies. And what they do is they provide tons of details in there. And they write the application as though it is a full non-provisional, but they file them as a non-provisional. Why do they do this? Because they can stack the life to extend the patent life to a total of 21 years. 1 year from the provisional, 20 years from the non-provisional, and you got 21 years. And for drug applications, the last year of life is worth billions. So that's the best way to do a provisional application. Now, you don't have to be that professional in order for the patent application to be good. What you have to do is look to make sure that there's tons of details in the provisional application and make sure that the company has a docket, make sure that it's filed before the 1 year period. Because here's the problem. If they miss the deadline and they sold their, let's say they went out and they did a proof of concept test to validate traction, let's say 6 months from the filing of the provisional, right? And they missed the 1 year deadline. Guess what? That means that they're going to have to refile the application, let's say a year after they filed the provisional, but they have a sale in between. Now, that sale or that open use of that software constitutes a public disclosure. And that public disclosure is prior art against any subsequent patent application. So if that situation happens, your patent is gone. Now, the only thing you can recover from that is now to patent version 2 of the software. In this day and age where anybody can code using AI, you need to have a strong patent to defend the exclusivity of the business. That's the recommendation that I have is, number one, check the quality of the provisional application, not for legally, but just for the technical disclosure details. Number two, make sure that they have somebody who's going to file the patent application as a non-provisional within the 1 year period, and make sure that they aren't just doing it themselves and they may forget about it. That's going to be a crucial loss of IP rights, not just in the US, but also in the rest of the world. So that's a takeaway for an investor.
So, let's take a software like Slack. Every 1 to 2 months, Slack pushes out a new feature or an update. Now, do they have to go through a new legal process before every feature release or update to the software? Or does an initial patent cover upgrades, or does it only cover it in its current form? And how do you navigate that process?
So what you're talking about is a very normal process for companies to release iterations of the product. So you always have version 1, version 2, version 3. You have Windows, 1 to now Windows 11, right? So you have iterations of this. The foundational patent, the base layer, the reason it's foundational is that it's the earliest expression of your inventive technology. So that is something that you file. And from a strategic viewpoint, we always keep that alive. And we do that through what is called continuation application. So let's say you file the first case, that case eventually is granted, and then it's issued as a patent, right? And what we do is before it issued as a patent, we file a descendant application that claims priority to the parent. So that is chained all the way through its entire life, because that first patent is foundational. It's the earliest description of your technology. And the reason why we do that is people who copy you, they're pretty smart. They're going to look at your claim and they're going to say, well, your claims require elements A, B, and C. and I'm just going to do A, B, or I'm going to do A, B, and D, and I'm going to design around your patent, right? So if we have that continuation going, there's always this uncertainty that whoever's trying to design around you have to deal with, is because they don't know what the claims are going to be. So very cheap way to keep your competitors at bay is through that use of a continuation process. The original patent application will not necessarily have everything that you have developed 10, 20 years downstream. Let's look at Windows 1 versus Windows 11. That's over, I think, at least a 20-year period, and there are tons of innovations in there. And I guarantee you that Microsoft got a ton of patents on them, right? But when we work with client is before you have a new release, we would come in 3 months before that, and we will work with the team, right? You're going to have a product manager, and you're going to have the engineering guys, and we'll talk to them and we'll say, okay, in this new release, what are the new features you're going to tout in your advertising literature? And once we identify that, that means that we can hone in on that, and we can say, oh, these are the new features you don't want people to copy. Okay. Then we ask the engineers, how do you implement this feature? Give us documentation of that. And that's how we can pull information out in a market-driven manner. Now, sometimes an inventor might say, well, these features aren't mentioned. I've come up with a super neat trick, but these features don't ever surface it up to be mentioned in the product, marketing brochure. Then, we'll assess with the team to say if those individual neat technology contributions should be patented. So it's a combination of it, but in my experience, driven mainly from the important product features claimed in the marketing literature, and then supplemented by whatever else some inventor might think, oh, I've created this super neat new algorithms to do X, Y, and Z. I just want to patent it because it's good for the business.